And I welcome members to the third meeting in 2014 of the Delegated-Powers and Law Reform Committee and ask members to turn off mobile phones. Agenda item 1 is a decision on taking business in private. It's proposed that the committee takes items 5 and 6 in private. Item 5 is consideration of the committee's draft report on the Defective and Dangerous Buildings Recovery of Expenses Scotland Bill. And item 6 offers the opportunity for the committee to further consider the draft Agricultural Holdings Scotland Act 2003 Remedial Order 2014, oral evidence on which was taken by the committee last week. Does the committee agree to take items 5 and 6 in private, please? Agreed. We do, thank you. That takes us to agenda item 2, which is instruments subject to negative procedure. The National Health Service General Ophthalmic Services Scotland Amendment Regulations 2013, SSI 2013-355. Regulation 3B and E substitutes new definitions of primary eye examination and supplementary eye examination in Regulation 2.1 of the Principal 2006 regulations. The meaning of the instrument could be clearer in respect that the definitions of primary eye examination and supplementary eye examination in Regulations 3B and E could be made consistent in referring to tests and procedures which are appropriate to the needs of the patient. The definition of primary eye examination for the purposes of the regulations has been modified to refer in general to other tests and procedures appropriate to the needs of the patient. The definition of supplementary eye examination has been modified to refer to the fact that it includes the tests and procedures appropriate to the clinical needs of the patient. Does the committee therefore agree to draw the regulations to the attention of the Parliament on a reporting ground H as the meaning of the instrument could be clearer? And does the committee also wish to note that the Scottish Government will lay an amendment in the next convenient opportunity, recognising as they do that it would be preferable for both definitions to use consistent terminology? Thank you, we do. No points have been raised by our legal advisers on the following instruments. The Police Service of Scotland Amendment Regulations 2014, SSI 2014-1. The Seafish Prohibited Methods of Fishing, Firth of Clyde Order 2014, SSI 2014-2. The Water Sewerage Services to Dwellings, Collection of Unmetered Charges by Local Authority, Scotland Order 2013, SSI 2014-3. The Environment Protection Duty of Care, Scotland Regulations 2014, SSI 2014-4. Sports Grounds and Sporting Events Designation, Scotland Order 2014, SSI 2014-5. The Common Agricultural Policy Schemes, Cross Compliance Scotland Amendment Regulations 2014, SSI 2014-6. The Less Favoured Area Scheme, Support Scheme, Scotland Amendment Regulations 2014, SSI 2014-7. The Long Leases Appeal Procedure, Appeal Period, Scotland Order 2014, SSI 2014-8, and the Long Leases Prescribed Form of Notices, etc., Scotland Regulations 2014, SSI 2014-9. Is the committee content with these instruments, please? Possibly also with the order in which they've been brought. Agenda item 3, a Housing Scotland Bill. The purpose of this item is for the committee to consider the delegated powers in the Housing Scotland Bill at stage 1. In considering the bill, the committee is invited to agree the questions it wishes to raise with the Scottish Government on the delegated powers in the bill. It is suggested that these questions are raised in written correspondence. The responses received will help to inform a draft report on the bill, and the committee will have the opportunity to consider the responses at a future meeting before the draft report is then considered. Section 21 of the Housing Scotland Act 1987 concerns rules made by social landlords regarding the priority of allocation of houses. In addition to the power conferred on the Scottish Ministers to make regulation, Section 4.2 of the Bill also inserts new subsection 3A, which requires a social landlord, in making or altering its rules governing the priority of allocation of houses, to have to regard to A, any local housing strategy for its area, and B, any guidance issued by the Scottish Ministers. The power to issue guidance to which a social landlord must have regard is not discussed in the Delegated Powers Memorandum, as it is not a power to make subordinate legislation. Does the committee agree to ask the Scottish Government for an explanation of the purpose of the power in Section 21(3)(a)(b) of the Housing Scotland Act 1987, as that provision is inserted by Section 4.2 of the Bill? In particular, whether it is expected that ministers will use the power to make guidance regarding the same matters as could be prescribed in regulations under new Section 21(3)(b), and if so, what considerations will inform the choice of guidance or regulations? and whether the Scottish Government intends to publish the guidance in light of the potentially significant effect on individuals of a social landlord's rule on housing allocation. Question. Stuart.
Convener, it might be just useful to make the observation that we seem to be, as a committee, saying to the government fairly regularly, if they're going to produce guidance, that guidance should be published. And it might be, if others are of the same mind as I, that a useful opportunity to simply say that that is what we are generally going to say, so that the government can take some account of that from here on in. And of course, I agree with the proposition you're putting.
Thank you for that observation. I'll be content with those questions being asked. Thank you. The bill also inserts a new section 20A3, which requires a social landlord, in considering whether to impose a requirement as to the minimum period before an applicant is eligible for an application of housing, to have regard to any guidance issued by Scottish ministers. The power conferred on ministers is to issue guidance on the same matters as may be prescribed in regulations under section 20A4 of the 1987 Act. Does the committee agree to ask the Scottish Government the following questions on this? The provision in section 20B3 of the 1987 Act, as inserted by section 7.2 of the bill, confers power on Scottish ministers to issue guidance on the same matters as may be prescribed in regulations under section 20A4 of the 1987 Act, as inserted by section 7.2 of the bill. In what circumstances is it envisaged that guidance will be issued as opposed to regulations being made? And whether the Scottish Government intends to publish that guidance in light of the potentially significant effect on individuals of a social landlord's rules on eligibility periods. I shan't invite Stuart Stevenson to say exactly the same point about guidance, but I think the point is well made. Are we content to ask those questions, please? Thank you very much. Section 8.1 of the bill amends Section 34 of the Housing Scotland Act 2001 on the creation of short Scottish secure tenancies. It inserts new subsection 9, which provides that a landlord must have regard to any guidance issued by the Scottish ministers regarding the creation of a short Scottish secure tenancy on the new antisocial behaviour grounds. As before, the power to issue guidance is not discussed in the Delegated Powers Memorandum, nor is it explained in any of the supporting documents accompanying the bill. In the absence of such explanation, does the committee agree to ask the Scottish Government the following? What is the purpose of the power to issue guidance in Section 34.9 of the Housing Scotland Act 2001, inserted by Section 8.1 of the bill? Why is it considered appropriate for the power to be exercised by way of guidance rather than subordinate legislation? And whether the government intends to publish guidance issued under that power? Thank you. Section 41 of the bill provides for the Scottish ministers, by regulations, to set out a code of practice which makes provision under the standards of practice, a provision about the standards of practice of persons who carry out letting agency work. Before finalising the code, the Scottish ministers must consult on a draft of it under section 41.3. The Delegated Powers Memorandum explains that it is considered appropriate for the code to be set out in regulations rather than on the face of the bill, as it may require a detailed set of requirements to be developed. Although this could be considered reasonable, consideration of the choice of parliamentary procedure may be appropriate. The bill proposes that compliance with the code of practice will have important legal consequences. Failure to comply could lead to revocation of a letting agent's registration under Section 35, or the imposition of a letting agent enforcement order under Section 43, and failure to comply with that letting agent enforcement order without reasonable excuse is an offence in terms of Section 46. Failure to comply with the Code of Conduct issued under Section 14 of the Property Factors Scotland Act 2011 has similar legal consequences in relation to property factor registration and enforcement, but the order bringing that code into force is subject to affirmative procedure. Does the committee therefore agree to ask the Scottish Government to explain why it is considered appropriate for the regulations setting out the letting agency Code of Conduct practice under Section 41.1 to be subject to the negative procedure? New Section 32N of the Caravan Sites and Control of Development Act 1960 gives the Scottish Ministers the power by regulations to make provision in relation to the procedures to be followed for an application for a site licence, an application for consent to a transfer, and the transfer of site licence on death. It also allows ministers to make provision in relation to appeals against a decision by a local authority to refuse a licence application, to transfer a licence, to refuse consent to a licence transfer, and to revoke a licence. Subsection 2 gives an indicative list of matters which the regulations may make provision for or in connection with. The power allows ministers to set out procedures and time limits in relation to site licensing system, and that this level of procedural detail is best dealt with through regulations. The Scottish Government considers a negative procedure to be appropriate. It would appear, though, that the power as drafted is not restricted to enabling provision to be made about procedural matters. In particular, subsection 1D enables provision to be made in relation to appeals generally, and not merely in relation to the procedure or time limits for appeals. Whilst the list in subsection 2 indicates some matters relating to appeals about which provision may be made, the power is not restricted to that extent. There is also no requirement on the face of the bill for a local authority to give reasons for its decisions to determine a relevant permanent site application or an application for a consent to transfer a licence under section 32E, or its decision to transfer a licence under section 32G. Does the committee therefore agree to ask the Scottish Government the following questions? Regarding appeals, if the power in section 32N is intended to enable provision to be made about the procedure and time limits for appeals, why is it drawn more widely than that? And what sort of provision regarding appeals it is anticipated the power will be used to make? Thank you. Section 32I of the bill requires a local authority to notify its decisions under the licensing regime to determine applications or to transfer licences. However, an authority is only required to give reasons for its decisions in the circumstances provided for in regulations made under section 32N1, if any. Giving of reasons is a significant aspect of procedure and could be expected to inform the decision of anyone with a right of appeal under section 32M regarding whether to exercise that right. Does the committee therefore agree to ask the Scottish Government the following questions? Why is it considered appropriate that these circumstances are subject to provision made in delegated legislation rather than set out on the face of the bill? And why is the negative procedure considered to provide an appropriate level of scrutiny for the exercise of such a power? Okay. Sections 32 and sections 63 and 64 of the bill insert new sections 32R, 32S and 32V into the Caravan Sites and Control of Development Act 1960. These provisions set the maximum fine on conviction of operating a caravan site without a licence, £50,000, the maximum fine on conviction of breaching licensing conditions, £10,000, and the maximum fine on conviction of failure to comply with an improvement notice, again £10,000. New section 32T of the 1960 Act gives Scottish ministers the power to amend these maximum fine levels through an order subject to the affirmative procedure. The reason given for taking the power in new section 32T is to enable adjustment of the maximum fines imposed in line with inflation and other relevant factors. However, although subject to the affirmative procedure, the power is not expressed as being restricted in that way. A comparative power in section 226 of the Criminal Procedure Scotland Act 1995 enables ministers to amend enactments passed after the 1st of April 1996 to substitute a new sum for a maximum fine specified in such an enactment. That power enables the substitution of a new sum only where ministers consider that the sum is justified by inflationary changes or to reflect the fact that the standard scale which applies to the other lesser offences is being increased. Does the committee therefore agree to ask the Scottish Government whether it considers that it might be appropriate for similar restrictions to apply to the exercise of the power in section 32T, and in the absence of such restrictions, does the Government consider the power taken in section 32T reflects the policy intention of taking such a power? Which brings us to agenda item 4, the High Speed Rail London West Midlands Bill, which of course is UK Parliament legislation. Under this item, the committee is invited to consider the powers to make subordinate legislation conferred on the Scottish ministers in the High Speed Rail London West Midlands Bill. A briefing paper has been provided which suggests that the committee could seek a written explanation of the parliamentary procedure aspects of clause 49 of the bill. The committee would then consider the response at a future meeting with the intention of agreeing a draft report. Accordingly, the committee may wish to ask the Scottish Government for an explanation of the following matters in relation to the powers in clause 49. An effect of clause 49(2)(b) is that the laid-only procedure will apply to an order made under clause 49(1) unless the conditions provided for in section 13(1) of the Transport and Works Scotland Act 2007 apply to that order. In that event, the order will be subject to the affirmative procedure. An order which authorises the carrying out of work constituting national development within the national planning framework would, by virtue of the application of section 13 of the 2007 Act, be subject to the affirmative procedure. The national planning framework includes, as the third listed national development, high-speed rail links linking Edinburgh and Glasgow city centres with London and offering good connections to the rest of the rail network. Does the committee therefore agree to ask the Scottish Government for clarification as to the circumstances in which an order under clause 49 to authorise works in Scotland for high-speed 2 phase 1 purposes would be subject to the laid-only procedure, when it would be subject instead to the affirmative procedure, and why that position is appropriate? Section 34 of the Interpretation and Legislative Reform Scotland Act 2010, hereafter referred to as ILRA, has the effect that orders under the 2007 Act are not subject to the laid-only procedures set out in sections 30 and 31 of ILRA, where they are not subject to the affirmative or negative procedures in terms of the 2007 Act. Instruments which are accepted by virtue of section 34 are not considered by the committee. Clause 49 of the bill does not apply or modify section 34 of ILRA. It appears, therefore, that an order under clause 49(1), where not subject to the affirmative procedure, would be subject to the laid-only procedure, and so would be considered by the committee. This would appear to be the position unless an order is brought forward under section 35 of ILRA to exempt an order under clause 49 from the procedure, as is presently the case for orders under the 2007 Act. Does the committee agree to ask the Government why this approach has been taken, whether there is any intention to either amend the bill or to bring forward an order under section 35 of ILRA? And that completes that item, and I move the meeting into private. Thank you very much. And there will be